This video is specifically about tort of nuisance that is implemented in Malaysia. My name is Nureen Rafiqah Syahirah and my metric number is A20BE0395 and I'm from Section 2 SBEH1093. This video will give a detailed explanation on how the law of tort is implemented. Law of nuisance is to provide comfort to persons who have proprietary interests in land and to members of society, generally through control of environmental conditions. Even though a person who has interest on his land or property, he can do whatever his heart desires, but he must not cause inconvenience or damage to another person who similarly has interest on their land. To differentiate between tort of nuisance, tort of negligence, and tort of trespass to land, these are the elements that can be compared. The first comparison is between nuisance and trespass to land. In nuisance, it is an interference to plaintiff's interest of his property and do not require physical entry by defendant, while trespass to land, it is a direct entry onto land and belongings to another and actionable per se without any proof of special damage. Nuisance is an interference with the use of land, while trespass to land is the interference with the possession of land. Next is the comparison between nuisance and negligence. Nuisance is an act or omission intentionally, while negligence is an act that is not intentionally and can cause annoyance. Public nuisance, which is a crime as well as a tort, and private nuisance, which is a tort. These are two categories of nuisance that has been mentioned. Now, let's look deeply into public nuisance that has been defined by the Attorney General vs. PYA Quarries Ltd and Majlis Perbandaran Pulau Pinang vs. Bowie, Siutan and Ors. Attorney General vs. PYA Quarries Ltd stated that public nuisance arises when an act materially affects the reasonable comfort and convenience of life of a class of the society, while Majlis Perbandaran Pulau Pinang vs. Bowie, Siutan and Ors stated it is a public nuisance if within its sphere, which is in the neighborhood, it materially affects the reasonable comfort and convenience of a class of the subjects of the state. The subject of the state is not necessary for every single member of society that must be affected by their interference. We can assume about 60% of the society affected will be enough for plaintiff to claim. For instance, hundreds of obscene telephone calls to at least 13 women over a period of 5 years were held to have constituted as a public nuisance. The person who may claim for public nuisance are criminal proceeding. Prosecution lies at the instance of the public prosecutor on behalf of the government. Civil proceeding that includes the person who suffers special or particular damage. Plaintiff who sued must not have interest in land in order to claim. Only who suffers damage and injury over and above their ordinary inconvenience suffered by the public at large. This is to prevent multiplicity of action that will be too harsh on defendant. Special and particular damage guidance. Type or extent damage more serious than the others who face the same interference. Is a personal injury or damage, and the damage must be direct consequence and substantial. For example, plaintiff suffers breathing problems due to defendant's smoke pollution. Lastly, the person who may claim is the civil proceeding that includes no special damage suffered by any particular individual. Attorney General or two or more persons who have obtained written permission from Attorney General may institute a suit in public nuisance for declaration and injunction of the case. Section 8, Part 1, Government Proceedings Act 1956. Next, let's look into private nuisance. It is an unlawful interference with a person's use, comfort, enjoyment, and any interest that a person may have over his land. Unlawful interference does not mean that the activity or conduct of the defendant is inherently unlawful. It will become unlawful when there are unreasonably interferes with the plaintiff's enjoyment of his land. To be able to sue the defendant, plaintiff must prove interference with the enjoyment of his land, and plaintiff must have interest in land, such as a landowner, tenant, licensee.
What is that noise? It is so loud. I can't concentrate on my revision at all.
Yeah, I think it comes from our neighbor. Let's go and check what's happening.
Yes, my neighbor, what do you want?
What do we want? We want silence.
Two ways to establish private nuisance are by substantial interference and unreasonableness. Substantial interference. Plaintiff is required to prove suffered damage in order to succeed in his claim. There are two types of damages stated. The first damage is interference with the use, comfort, and enjoyment of land, is a feeling of discomfort whereby one is unable to live peacefully and comfortably on one's own land. Next, material or physical damage to land or property. It is the actual damage that not recoverable automatically. Unreasonableness. As been mentioned from previous slide, the first requirement in establishing nuisance is to prove the interference is substantial. In determining what constitutes substantial interference, the plaintiff must further prove the interference caused by defendant to be unreasonableness. These are the factors to determine the interference is unreasonable and actionable. The first factor is damage and location of plaintiff's and defendant's premises. For instance, in the case of Syarikat Perniagaan Selangor Sendirian Berhad versus Shahrolizam Mohd and Ors, the appellant who had leased over a piece of land had agreed and promised to use the land as a skating rink, restaurant, and a cinema. The appellant subsequently built an open stage and staged some shows. He also opened a discotheque. The court held that people who live in the urban must be prepared to accept a lot of noises from their neighbor, and he himself may make noise. But no one, however, has the right to create excessive noise. Similarly, a person is not required to tolerate an excessive level of noise which is unreasonable and is nuisance. Let's move to those who can sue the offender or defendant, who has some proprietary or other interest in land that can maintain an action, such as landowner, tenant, licensee, possessor, and reversioner. Is a landowner who is not in occupation at the time the interference takes place, but who is expected to resume occupation at future date. Let's move to who can be sued by the claimer or plaintiff. There are a few people that can be sued, such as creator, occupier, servant or employee, independent contractor, trespasser, licensees, and others. First, creator. He is whether or not he occupied the land where interference emanates. Occupier. Most of the cases, a defendant is the occupier of land from which interference emanates. Servant or employee. The person who are subjected to his control. Next, trespasser. Without the act, authority, or permission of occupier, the occupier is not responsible unless, with knowledge of its existence, he suffers it to continue without taking reasonably prompt and efficient means for its abatement. We continue to the defendances that applies to an action for tort that relevant to nuisance. There are three defendances that the defendant can claim, which are prescription, statutory authority, and other defenses. First, prescription. Defendant has to prove that the interference is an actionable nuisance to occur for the whole 20 years. Statutory authority. Statute confers power to defendant to conduct a particular activity. Defendant must prove that the interference cannot be avoided even though reasonable precautionary measures have been taken.